I invite the moderator, Honorable Mr. Justice A. Muhammad Mustaq, the speakers of the day, and the team members to be seated in the dais. Good evening, everyone. Today we all have gathered here to be the part of the event hosted by Constitution Debate Club, High Court of Kerala, in association with Kerala High Court Advocates Association. The topic for the day is laws which protect husbands from prosecution in cases of marital rape is unconstitutional. Let's begin the event with a silent prayer. I request you all to kindly rise for the same. You may all be seated now. I invite Advocate Rajesh Vijayan, President, Kerala High Court Advocates Association, to welcome the gathering.
Good evening. ബഹുമാനപ്പെട്ട ജസ്റ്റിസ് മുഹമ്മദ് മുസ്താഖ്, മറ്റ് ന്യായാധിപരെ, സീനിയർ അഭിഭാഷകരെ, സുഹൃത്തുക്കളെ, ഇന്നിവിടെ നടക്കാൻ പോകുന്നത് ഒരു ചർച്ചയോ ക്ലാസ്സോ സെമിനാറോ ഒന്നുമല്ല, തർക്കമാണ്. തർക്കശാസ്ത്രം എന്നുള്ളൊരു ശാസ്ത്രശാഖ തന്നെ വലിയ പ്രാധാന്യത്തോടെ ഭാരതത്തിൽ പ്രത്യേകിച്ചും ഉണ്ടായിരുന്നു. അതിന് നിരവധി റൂളുകളുണ്ടായിരുന്നു. പല രാജാക്കന്മാരുടെ ദർബാറുകളിലും താർക്കികന്മാരുണ്ടായിരുന്നു. ഈ താർക്കികന്മാർ പല വിഷയത്തെക്കുറിച്ചും തർക്കിച്ച് അതിന് പല റൂളുകളും, ആഗമനാത്മകം, നിഗമനാത്മകം, ഇതൊക്കെയാണ് തർക്കശാസ്ത്രത്തിലെ റൂളുകൾ. അത് നിരവധി ദിവസങ്ങളോളം ചർച്ച ചെയ്തിട്ടാണ് പ്രത്യേകിച്ച് ഓരോ ഇഷ്യൂസിലേക്ക് അവസാനം എത്തിച്ചേരുന്നത്. ഇന്ന് ഇവിടെ നടക്കാൻ പോകുന്നതും അതുപോലൊരു തർക്കമാണ്. അസോസിയേഷൻ്റെ വക 6 താർക്കികന്മാരിവിടെ റെഡിയായി വന്നിട്ടുണ്ട്. ഞാൻ എൻ്റെ കടമയിലേക്ക് കയറട്ടെ. ഈ തർക്കത്തിൻ്റെ മോഡറേറ്റർ ഓണറബിൾ മിസ്റ്റർ ജസ്റ്റിസ് എ മുഹമ്മദ് മുസ്താഖ് അവർക്ക് ഞാൻ ആദ്യമായി സ്വാഗതം ചെയ്യുന്നു. ശ്രീ ജേക്കബ് പി അലക്സ്, presentation of debate design, Dr. Tushara James, Justice Bechu, Justice Sophie Thomas, Justice Basant, മറ്റ് സീനിയർ അഭിഭാഷകരെ, സുഹൃത്തുക്കളെ, എല്ലാവരെയും ഔപചാരികതയുടെ പേരിൽ ഞാൻ സ്വാഗതം ചെയ്യുന്നു. അധികം സമയം അപകരിക്കുന്നില്ല.
Now I invite Advocate Jacob P. Alex, Vice President, Constitution Debate Club, for presenting the debate design.
Good evening to all. The debate design, the introduction of the topic will be initially made by Honorable Moderator, Honorable Justice Muhammad Mustaq. After that, we are having 2 teams, proposing team and opposing team, 3 speakers each in these 2 teams. Proposition team headed by Senior Advocate S. Sri Kumar, Advocate Karthika Sukumaran, and Advocate P.G. Jayashankar. opposition team headed by Senior Advocate Gracious Kuriakos, Advocate Santosh Matthew, and Advocate Mita Sudhindran. And each speakers will get 10 minutes to present the topic. On the 9th minute, there will be a warning bell, and once it completes 10 minutes, the time out card will be shown, and then moderator will intervene and stop the presentation. So we'll have to adhere strictly to the time limit of 10 minutes. The order of presentation would be initially from the proposition team. The junior most member will make the presentation for 10 minutes, will speak for 10 minutes. So that means initially Advocate P.G. Jayashankar will speak for 10 minutes. Then from the opposition team, the junior most member, Advocate Mita Sudhindran, will present for 10 minutes. Thereafter, from the proposition team, Advocate Karthika will present the topic, will speak for 10 minutes. Then Advocate Santosh Matthew, then Advocate S. Srikumar and Advocate Gracious Kuriakos. After that, if time permits and moderator finds it appropriate, then moderator will permit very few questions from the audience. And you can ask questions to any one of the speakers subject to permission by the Honorable Moderator. Then the concluding remarks will be made by moderator. So this will be the design of the presentation. Thank you all.
Now I humbly invite the moderator of our event, Honorable Mr. Justice A. Muhammad Mustaq, Judge, High Court of Kerala, to introduce our topic for the day.
Audience will ask questions except to the moderator. My sisters and brothers, judges, the lawyers of the Kerala High Court and others, is happy that Bar Association also now engaged in a serious business. And Rajesh Vijayan also now may start posting in Facebook with a lot of serious note on the topic like this. Well, I have been also saying, I've been allotted 5 minutes to speak. Definitely I will adhere to my time schedule. Because everybody, the working day, everybody wants to go back to home earlier. But I congratulate the Debate Club and Association for initiating this debate. I'm resuming this program again. It's more than after two and a half years or something like that. Well, before relating to the topic, I just want to comment upon certain things which I saw a Bar Association resolution, I believe it's from Trivandrum Bar Association, depicting young lawyers and students in a bad shape, in a sense. They are not much serious about court and court proceedings, etiquettes to be maintained in the court. Of course, that is correct. I also believe many of the youngsters who have enrollment, they believe that is an extension of the campus. But I don't feel they are responsible for the malady now they face. In fact, the elders in the bar are responsible for the same. So youngsters cannot be blamed, but we are the responsible for the simple reason that we are all had a pupillage or a different kind of exposure at the initial stage, working under the senior, in an era where we have to browse all the books, library, journals, we have to ask the seniors. So there is a pattern of pupillage at those times. So that was a serious business. So nobody has time to have some other leisure or in the court or anywhere. So they have to be involved in everything, in the litigations, looking at the digest, looking at the journals, browsing every pages. So they looked upon those times with a very serious, mind, because such a pattern of pupillage was followed. But now we believe that same has to be recreated. That's where we went wrong. You can't create the same environment in which we all brought up. You are living in an era of technology where everything is available on the fingertips. And when Google has become a god, Internet has become a prophet, you can't expect the same kind of mindset of the youngsters. But still, we can provide a creative space for them. That's where we are really missing. I think in the debate like this, program like this, really give them a space, a more creative role in shaping themselves a future way. And this is how the lawyers has to mold it. So merely condemning them is not a good, cannot find its resolution. We have to mold them and guide them. And this is the one method. And I should every bar, including a Trivandrum bar or any other bar, if we feel that youngsters are on the wrong path, they are not very serious and responsible, it is our responsibility to mold them and mend them. Then relating to the topic, I want to relate three aspects to it. When topic like this, in being debated, sitting just cannot express any opinion. We have our own restraints and constraints. With that in mind, I want to relate three aspects in this. Because it ultimately has to be tested, and every law has to be tested in the envelope of Constitution and its parameters. Constitution, the basic document for us, it profers the human dignity to everyone. So what is that human dignity we are talking about? It must be contextually relevant in every society. The basic human rights is all is human dignity. And it is something like an intrinsic value each one possesses. The self-respect one has. And right to take a decision of his body and person. These are all part of human dignity. You can't eschew such human dignity while interpreting a law or when you're looking in terms of the constitutional scheme. This is one aspect I just thought of referring while the both debaters will, of course, they may their own way of dealing it. But basically, we must not forget that what Constitution promised us that to live a life with all human dignity. Human dignity encompasses many things: bodily integrity, decisional autonomy, etc., self-respect, etc. Second aspect is related to equality. So everyone, the Constitution also promises protection in all circumstances, in equal measure. That means kind of gender neutrality be followed in certain areas when law can't differentiate the kind of offense merely based on the gender. That's something which we have to look at it. The Constitution's promise equality to everyone. So if it's a harm to you, it's a hurt to you or injury to you, it has to be injured to everyone without any gender identity of it. That's one aspect of this topic. And third aspect, according to me, is the efficacy of the existing law. Perhaps our problem is everything we relate, every issue now we face, we confront this phase or being encountered, we relate it to the existing law. This is how we have a real problem with the promise to marriage, whether it falls under the rape or not. See, the laws are made at a time when a social structure we followed in a particular time is totally different from now. With all our patriarchal mindset, the society followed. That fabric was that. If you could look at all the laws that made at that time, you will find the women is so dependent upon the men. The dependency is reflected in every law we had. At a time where it was thought, because you know that all the laws are made by men. Most of them are in our parliamentary and legislatures are men. To govern whom? Women. They have no voice. And those laws we have to follow in all the times. So efficacy of the law is something we have to think about. We can't relate every issue now faced to related to existing law. The clearest example is the promise to marry. A male and women may live together, reside together, of course, in believing that they will marry, and all of a sudden, if marriage is not happened or someone is reglowed, alleged rape. But what is the provisions of law which could attract in such circumstances? We jump over the high provisions of IPC 375, 775, or 377 related to it. But court or pass on a verdict that it cannot be related to IPC, every human cry will be, everyone raise an eyebrows. This is the problem of, is not with the court, but with the law, efficacy of a law dealing with many of issues which never we had in the past. How are you going to deal with such issues? So that is, we don't have such kind of law in a kind of incidents of or kind of injury or offense that may occur in marital relationships. We don't have such kind of law in India. Similarly, we also feel when I sit in the matrimonial jurisdiction, of course, it has nothing to relate with today's topic. We often find the many of issues relating to the dispute relating to the properties is basically for the reason that even though spouses want to separate, because the women involved and feel that they have been deprived of all financial security. What is being offered is a pittance towards maintenance. All the years she spent all the time taking care of the household and taking care of husband, all of a sudden has to walk away from the marriage without anything. And lawyers have no other way of raising a claim by imaginative ground of misuse of the gold ornaments or something like. So we don't have any law relating to the matrimonial property. So these are the problems of the times. So we can't relate existing law with all what we now face in the time. This is where also debate has some dimension. I believe they should also enter into such areas. So with these words, I conclude. I wish both team all the best. Thank you.
Thank you, sir. Now we have come to the most awaited part of the day. Here begins our debate session. And our first speaker of the day is Advocate P.G. Jayashankar from the Prosecution team.
Most respected judges, and my dear seniors, and my brothers and sisters. I stand here with the proposition that the exemptions which are provided under the Indian Penal Code, which exempts the culpability of husbands from the penal provisions, are unconstitutional. Since there is, I do not have too much of time, I'll just directly enter into the specifics. Rape specifically is defined under the Indian Penal Code under section 375. The subject of this discussion or this debate is as to whether the marital rape exemptions, which are provided under exception 2 to section 375 and section 375B of the Indian Penal Code, is constitutional or not. For the purpose of debate, I'm just quoting the exception. It says, sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. My suggestion, in fact, as far as the exception itself is concerned, is something which, as a civilized society, we should never have accepted. And when it was drafted in 1860, it should not have crossed 1950, once the Constitution had come into force. May I just point out one aspect? When we had the Constitution in 1950, we had a very, very limited understanding or rather implementation of even the right to life. In 1950, we had the decision of A.K. Gopalan. But we traveled a long way. When we reached in 1978, when we reached Maneka Gandhi, that every aspect that was highlighted in A.K. Gopalan had changed. The law evolved. Rather, I would rather use the term constitution graduated from procedure established to almost accepting the concept of a due process. But has any of the penal laws been timely evaluated? Has it ever been examined? I will be putting up the proposition before this August assembly as to why the exceptions are violative of Articles 14, 19 and 21. And in fact, which would be followed up by the learned seniors in the proposition team as to why there has to be a change in accordance with the change of time or the advancement of the society. As in the case of any issue relating to the constitutionality, we need to examine the exception of marital rape or MRE, marital rape exception, with the touchstone of Articles 14, 19 and 21. We, at this point in 2022, we have from the unenumerated or rather the smallest concept of right to life, we have now realized that the right to life under Article 21 is not just one single right to life, but it is a bouquet of rights, starting from the right to live with dignity to right to live with autonomy and what not. Now, may I very specifically point out, when the Honorable Supreme Court said that right to privacy is a recognized fundamental right, what was the impact of that? It is not just that the court was declaring that there is such a bouquet of, that Article 21 is not just one simple right, a bouquet which contains all those rights which are so essential to ensure that we all live with the dignity that we deserve, which essentially is something which stems out of not just Part 3 of the Constitution of India, but rather from the concept of human rights. Now, let us see how or what is included in Article 21. It is a right to life, which can only be taken away with a due procedure or a procedure established by law. This right to life has been variously explained. As I said earlier, right to dignity, right to live with, right to autonomy, the right of privacy, and this in fact, in my suggestion, this in fact encompasses the entire gamut of rights that that a lady requires, a lady as an individual, as a human being deserves to be in this world. The facets of right to life, that is right to bodily integrity, right to autonomy, right to dignity and right to privacy, are the four rights that I would like to place before this August gathering. Now, when it is said that a woman does not have, or rather a man cannot be punished for an offense of raping his wife, what does it entail? It entails the outright violation of a woman's right to dignity merely because she happened to be married to the man. Doesn't mean that she has to be she deserves a treatment which is lesser than any other individual in the society, be it a man or a woman. Now, therefore, in that context, when it is defined that the performance, the sexual intercourse or sexual acts by a man with his own wife, where is the question of a consent? There is no consent. So it means the law directs or mandates that the husband, the perpetrator, cannot be prosecuted. Now, in this context, when it is said that the husband cannot be prosecuted, is it just that the woman or rather the wife is deprived of one right? No. See, as far as the woman is concerned, she has a right to say no. She has a right to give consent, as in the case of any other woman or any other individual in the society. By specifically taking out this right or to say no, I would submit that the exception 2 puts a restriction on the woman from saying that she has no right to object. She has no right not to consent. Now, this therefore results in a situation where she is forced to be subjected to sexual acts which causes a lot of mental trauma, results in her dignity being affected, results in her autonomy, results in her decision, the decision regarding procreation, every aspect of it, every aspect of a right of a lady is affected. Is it just that it is a violation of Article 21? No. When we are speaking of consent, there is also another facet to it. That is a right of freedom, right to freedom of speech and expression. As an individual, any person in this in our country has got every right to express whatever he has got, whatever he wishes for. But when it comes to family, going by the traditional notions that we can see in the marital rape exception, the wife unfortunately is precluded from expressing her objection. Of course, she can express her objection, but nonetheless, these acts can be committed on her. What does the law provide to protect her? This differentiation or this action on the part of the law, which takes away her right to withhold her consent, right to say no, is not just therefore a violation of 19. Therefore, it is to that extent a violation of reasonableness or a violation of her right to equality. As far as equality, again, coming to Article 14, these exceptions that are provided, exception 2 as well as 375B, also creates two classes of persons as far as the victim is concerned and as far as the perpetrators are concerned. As far as the victim is concerned, it creates a class where a person, merely because she happens to be the wife, she cannot be treated as a victim of rape. Consequently, there are procedural defects also which also entail. For example, unless in a case of rape, the provisions of Section 51A of the CRPC, for example, the examinations of the accused, etc., does not arise. Similarly, in the case of husbands also, the same person, if he happens to be the husband, commits an act of rape on a lady, and merely because he happens to be the husband, he is separately classified. So, therefore, as far as the victims and as far as the perpetrators are concerned, there are classifications which are made by the statute, which has absolutely no, I would say, no intelligible differentiation. Now,
your time is up.
I'll just conclude with one aspect. Now, we have all mourned the death of various persons, Vismaya, Soumya and Nirbhaya. Very unfortunately, we have mourned the death of Soumya and Nirbhaya, the way in which she was treated cruelly. But Vismaya, we have mourned the death only after the entire incidents have happened. We said it should not have happened. Unfortunately, the dignity of the family was upheld by the society till that point of time, which forced her or drove her to commit suicide. I think as a society, we need to change this attitude, and as lawyers, we should definitely propose to change these unconstitutional provisions which are there, which are existing in the Constitution. Thank you.
Now we have Advocate Mita Sudhindran from the opposition team.
My name is Mita Sudhindran, and I, along with my learned team members, are arguing against the motion to contend that the laws which protect husbands from prosecution in cases of marital rape are constitutionally valid. Before I begin, I would like to clarify that we strongly condemn any sort of violence and that we feel that it is abhorrent for a man to impose himself on his wife. None of our arguments imply that marital rape or spousal abuse is acceptable. We only seek to highlight that the impugned provisions pass the test against Part 3 of the Constitution and thus ought to be altered only by legislative action. The broad grounds on which we urge against the motion are, firstly, that the marital rape exception is made on intelligible differentia and is a reasonable classification. Secondly, that the impugned provisions are not remnants of pre-constitutional or colonial design, but have been purposively and consciously retained by our Parliament, despite the recent amendment of our Section 375 in 2013 after the Nirbhaya incident. Thirdly, that there already exists a legal framework to provide redressal to a woman who is assaulted by her husband. Fourthly, that striking down the impugned provisions would amount to the creation of a new offence by the judiciary, which would fall foul of the doctrine of separation of powers and would transgress the scope of judicial review. Fifthly, that the sanctity of marriage is a social reality that must be factored in to harmoniously construe our laws. Sixthly, that striking down of the impugned provisions in the absence of a specific procedure for prosecution of marital rape would be ineffective and possibly counterproductive. Moving on, I would like to firstly rebut the contention of my learned friend regarding the classification pertinent to our discussion. The specific argument is that the classification is not reasonable or there is no national nexus with regard to the purpose of the Act. However, what I would like to state is that the Penal Code has envisaged a scheme of classification where the broad genus is that of sexual intercourse between two persons. From this broad genus of sexual intercourse between two persons, an exception has been carved out with regard to sexual relations within a marital relationship. From this genus, what is left, there has been a species that has been carved out with regard to Section 375, that is rape. Therefore, thus, there is this larger genus of sexual relations between two people. Within that, it has been carved out. All relations, sexual relations within a marital relation have been carved out. And what is left between sexual relations beyond a marital relation, certain relations have been penalized under 375. It is pertinent to note that the IPC actually proceeds to penalize certain provisions on the ground of consent and effectually age. This is the main reasoning behind the structure of 375. Thus, my contention is that the marital rape exception reflects a reasonable classification based on the peculiar nature of the relationship between spouses, which is characterized by sexual intimacy. The existence of a marital relationship cannot be ignored while considering any sort of transaction between a husband and wife. Forget the issue of rape. Any sort of transaction between a husband and wife cannot be considered in isolation of the fact that they are married to each other. It is also pertinent to note that this classification, which is based on the nature of relationship between the victim and the perpetrator, is not found only here. It is also reflected in 376, which penalizes rape. There are different punishments provided for rape if it were done by a police officer or by a public servant or by a relative or by someone who the victim is under the guardianship of. So these differences, this distinction has been made on the basis of the nature of the relationship between the victim and the perpetrator. And thus, I contend that the classification based on the relationship between the victim and the perpetrator is reasonable and rational. It is also a positive to mention that this type of classification is found even with regard to other offences, even murder. Section 304B, we all know how it is a distinct offence carved out with regard to a woman who is found dead within 7 years of her marriage. And the presumption is hoisted upon this husband on the basis of this particular marital relationship that he has. So a challenge against this cannot be upheld. A challenge against the classification that is used in 375 cannot be upheld is my contention. And that the classification on the basis of the nature of the relationship of the victim with the perpetrator is relevant for considering the offence of rape. I would like to further urge my contention by reiterating that the treatment of unequals or the identical treatment of persons in unequal scenarios would actually perpetuate inequality. Suppose the concept of consent which is imposed upon normal in the sense a case where a stranger rapes a woman, if that identical conduct of consent, a husband during a prosecution for rape of his wife, the inequality and the injustice that would be met to him cannot be countered. Now moving on to, so my submission is that Article 14 is not violated by the specific classification that is used in 375. I further urge that post Maneka Gandhi, as already mentioned, the more befitting test for constitutionality has to consider that Article 14, 19, and 21 are inextricably entwined in the holy trinity of fundamental rights. Liberty cannot be curbed or infringed except by procedure established by law. And in here, with regard to 375 and rape matters, what has happened is this genus of sexual relations where marital relationship forms a subspecies has been carved out from penal consideration and has been relegated to the sphere of family law, which is governed by personal laws, the DV Act, and also the penal provisions do have a limited application here, which will be further elaborated on by my learned team members. Moving on to my second contention, I would like to rebut the statement that Section 375 has not been revisited since its introduction onto our statute books. Actually, in 2013, there was an overhaul of the provision and it has been altered significantly, but the exception has been retained. Moreover, my contention is that the retention of the marital rape exception on the statute does not indicate that the Parliament justifies the act of marital rape. It need not establish that. It only establishes that the Parliament deems the IPC inappropriate or insufficient to presently prosecute offences of marital rape. I would also like to mention that, like the impugn provisions, the concept of rape, the offence of rape, also finds its birth in erstwhile Coventry and consent laws that state that a woman is property of her husband or father or whoever, some sort of male adult. Despite that, we have evolved to interpret and view rape laws from a position of dignity, to pivot it in the concept of consent. My submission is that the same sort of contemporary perspective should be adopted while considering the impugn provisions, to understand that these provisions are not remnants of colonial design or pre-constitutionally that they ought to be subject to further scrutiny. They have been purposefully and consciously retained by our Parliament. This is evident from the fact that various documents and various procedures have actually considered the issue of marital rape. The legislative wisdom cannot be discounted in this matter. There was the Verma report which said that marital rape should be brought on record. However, the Law Commission report, the last Law Commission reports mentioned that marital rape cannot be brought on record as an offence. I would further like to contend that the legislature's endeavour in treating spousal sexual violence as a species specifically distinct from rape within the meaning of Section 375 is further clarified by considering Section 376B. It is not that the legislature is unaware that such sort of violence could occur or that it will not occur. Moreover, hence, this is not some sort of, it has not been overlooked by the legislature, but it is a conscious decision taken by them. Actually, 376B says that sexual intercourse committed by a husband during separation shall be penalized, but on a lesser footing than that of 376. I reiterate that forced sexual intercourse, whether within or beyond a marriage, is despicable. Suppose the husband were to use force or intimidation in committing marital rape, the wife could trigger other provisions available in the penal code, like the provisions for grievous hurt and also 498A. But this will be further elaborated on by my team member. And also there are also provisions in the DV Act which do provide redressal to a woman. Moreover, sexual abuse clearly falls within the realm of cruelty.
Your time is up.
Within the realm of cruelty and would be a tenable ground for a wife to seek divorce. if I may end on a lighter note, what punishment could be worse than losing your better half? Thank you.
Next, we have Advocate Karthika Sukumaran from the Prosecution team.
Good evening, everybody. Rape is a rape is a rape. It makes no difference who the perpetrator is. The fact that the rapist is your spouse makes no consolation for the trauma suffered by the wife. So, how did the marital rape exception find its way to the statute? We are talking about a statute of 1860. The legal research regarding the marital rape exception shows that it is traced to a jurist, Matthew Hale, who said in 1736 that the husband cannot be guilty of rape committed by himself upon his lawful wife, for by the mutual matrimonial consent and contract, the wife had given herself up in this kind to her husband, and which he cannot retract. How relevant is this remark or finding of the jurist in 2022? This random remark of the jurist found its way to the common law. From the common law, the British colonial period ensured that it finds a place in the statute of Indian Penal Code. In post-constitutional India, does it deserve a place? Do we consider women in India as chattels? Have the courts in India accepted the fact that that women are property? No. On the contrary, the 1950, the Bible on which that we, even I, stand before you today, because of Article 14, because of the constitutional protection and the guarantee that a woman can work, because the woman can enter the legal profession. There was a time when the social concepts did not allow women to get educated or work, but remained a person within the walls of the home. Those days are gone. How long can we hang on to these concepts? Woman in the workspace. A woman, because of marriage, denied promotion. That's what Nargish Mishra's case taught us. Supreme Court said, no, it does not pass the test of Article 14. She deserves the promotion in spite of the marriage. So, the concept of marriage has an impact on the life of woman. Now, what is 375? We are not carving out an offense, a new offense, as the criticism would say, critics would say. The offense is already in the statute. That's spelled out by Section 375. My friend read about 375A to D, which relates to the act which constitute, the physical act which would constitute a sexual intercourse, which would form the basis of the physical aspect of rape. But do we forget the next 7 descriptions given therein? First, against her will. Secondly, without her consent. Then, from 3rd to 7th are situations where the consent is not free. So, 375 in itself, the very statute, the very section relates to 2 aspects of will and consent of the woman. Now, carving out an exception for a married woman that does not pass the test of Article 14 is my argument. When we talk about the exception, are we not admitting that there are situations where that marital rape occurs? So, an offense or a crime which fits in 375 happens within the four walls between spouses. And we are saying that to save the husband from the sanction of the punishment, to save the family. What is the family when there is violence between the spouses? Is that the family in which a woman, a modern woman, aspires to be part of? And can we say the concept of family is so sacrosanct? Have we not abolished joint family system, which we would never have thought maybe 100 years back? Could the society ever have envisaged a situation where there would not be a joint family? Of course, legislature stepped in. Now, what happens when the legislature does not step in to protect not an isolated community, a huge community, that is a group, the married women? This exception is discriminative in the sense it does not give equal protection of law under Article 14 is what I would say. It's not merely for equality before law. It's also equal protection of law. Why would a married woman not be protected? Why would this exception work against her? So, on coming to the next aspect that my friend said with regard to classification, that it is a reasonable classification. The classification is between married women who suffer rape and married and unmarried women. What is the impact of rape? What is the concept of rape? What is the ingredient of rape? All these are present in both sets of people. Then how are they different? The difference is only with regard to the perpetrator. And that is not a consideration for an act to be termed as a crime under 375. Now, we also, one aspect that was said was with regard to the lack of procedural backup in case the exception is withdrawn. In 2022, we cannot say that the law will stand still and that it will not move on. 2020 came an epidemic. The whole world changed. We moved on to digitalization instantly. We moved on to a separate set of rules completely. Hitherto unknown, court. What is the definition of court? Did we not change it to suit the times? Could we have sat back for 2 years without doing anything if we did not imbibe the change and use the technology to advantage? So it's not enough that we say that the procedure is not there or we do not have the procedure or the establishment to take care of it. You have to evolve procedure. If there is a crime, there should be a solution for the victim. That's one aspect of it. Then legislature's wisdom. With regard to legislature's wisdom, we are talking of a concept which evolved in 1736. 1736 is almost 300 years ago. It's almost 300 years ago. And we are still waiting for the legislative wisdom to catch up for all these 300 years? Definitely no. After the Constitution, we don't have to wait because we can test every legislation on the anvil of Article 14. A woman need not sacrifice Article 14 or 21 at the altar of marriage, is what I would say. Article 21, which has been very well interpreted by the Supreme Court in the context, in various contexts. have clearly said life is a dignified life. Now, is the life of a person whose right to express no or right to say no to a situation. It is part of marriage, they say. A sexual relationship, consensual sexual relationship, no doubt, is part of a marriage. But right under 21, a right to live with dignity, cannot be sacrificed to become a victim of rape. We have come far, very far, in the last 300 years. And when the Constitution was embraced by we the people, this we includes married women. The constitutional protection under 14 and 21 is for the married women as well. Thank you.
Now we have Advocate Santosh Matthew from the opposition team.
Good evening, ladies and gentlemen. My learned friend quoted one Matthew who made a statement about 200 years back. And it's a strange coincidence that another Matthew is standing before you to defend the existing provisions. As my young friend Ms. Mita said, foundation of a marriage is based on trust, respect, and dignity. Marriage is not a license to treat one's spouse the way one wants. And we are not opposed to criminalization of spousal sexual offenses. We are also not trying to justify non-consensual sexual relationship between the spouses. Our main contentions here is that there cannot be a criminalization of an act through a court intervention. Because all that has been reported earlier, various judgments which I'll be referring to, are cases where offenses have been decriminalized. And I am yet to come to a case where there has been a criminalization of an offense. And we are also trying to emphasize the fact that the existing framework is sufficient for taking care of sexual offenses relating to marriages. Now, as far as the Indian Penal Code is concerned, offenses have been broadly defined and categorized. Chapter 16 deals with offenses affecting human body. Then, as far as Chapter 20 is concerned, these are offenses relating to marriage. Then Chapter 20A is cruelty of husband and relative of the husbands to a wife. So there are adequate safeguards to meet any sexual harassments as far as a spouse is concerned. So according to me, there is sufficient framework, and there is also the Protection of Women from Domestic Violence Act, and it specifically talks about sexual abuse. Now, the Honorable Supreme Court had occasion to consider the definition of Section 2Q and defined and interpreted respondent to mean an adult male could bring in within the definition a woman also. Now, main reservation seems to be that the provision Section 375 starts with a man is said to commit rape. I think it is high time we have to discuss whether can't a woman commit a rape. Because if it is against a consent about a person, there are various instances world over whereby you have gender neutral acts whereby you can think about an offense being committed by the woman against a man also. But because the provision is couched in such a way that man is said to commit rape under 375, it warranted or necessitated an exception. Now, just to clarify one aspect, that it is 300 years ago this law has come, etc. Section 375 has been substituted as per Act 13 of 2013 on 2/4/2013, whereby the entire provisions has been substantially overhauled, and the legislature thought it fit to retain exception 2 also. So it is a conscious effort, and it is not a pre-constitutional law, and Article 13(1) will not come to the help of arguing for a void provision as far as the exception is concerned. Now, as far as the instances where courts have decriminalized, etc., I just wanted to say that there cannot be a class of offense created by a court. Shreya Singhal, the Honorable Supreme Court considered decriminalization of an offense under Section 66 of the IT Act. In Navtej Johar, constitutional validity of Section 377 was interpreted, and the Honorable Supreme Court declared that as far as criminalization of consensual sexual act between adults of the same sex is concerned, that cannot be criminalized. So these are instances where the Supreme Court considered provisions and declared that these cannot be criminalized. Then coming to the case of triple talaq judgment also, Shaira Banu's case, there also after declaring triple talaq to be unconstitutional, the Supreme Court left it at that. Criminalization was left to the Parliament, and only after it was made an offense in 2019 that it was made an offense for declaring or performing triple talaq was made an offense. So even if there is a declaration sought for that it is violative of Article 14, etc., it can only be declared to be bad in law, but it cannot be made a criminal offense. Counter would be that it is already there in the main section, etc. But when you are having a definition that a man is said to commit rape if due to following aspects, etc., it contemplated, because it has to be read in a substantial way, holistically, because Indian Evidence Act was amended on the same day with from 3/2/2013, specifically incorporating Section 114A, whereby consent was specifically said that if there is an inquiry and the woman states that she has not given consent, the court should presume that she has not given consent. Similarly, Section 198B has been introduced on the same day, whereby the courts have been given an obligation to take cognizance only after a preliminary inquiry and a prima facie satisfaction regarding the same. So the scheme of the legislation specifically carves out an exception as far as marital relationship is concerned. So according to us, there are enough and more safeguards as far as the law is concerned, and the court cannot, by invoking its jurisdiction, criminalize an offense. Now, as far as creation of an offense is concerned, it would require a definition, it would require a process, it would require safeguards, it would require evidentiary standards, and it would require a forum also. So if you are making a particular offense or carrying out a special category of offense for marital rape, I think the entire confusion seems to be what my learned friend started by saying: a rape is a rape is a rape. Now, if you are considering that is a framework, when you are talking or branding this also as a rape, when you're looking at various family law legislation, also restitution of conjugal rights is there. They presume consummation of a marriage. Non-consummation of a marriage is a ground for divorce. So these are all legislation which presupposes a sexual activity as part of a marriage. So once that is there, to have a broad definition as contemplated under Section 375 warranted an exception also. That is why the legislature in its wisdom decided to carve out an exception, and which can withstand the test of Article 14 and 21, because there is a reasonable classification and there is an intelligible differentia in having this category also. I think we are waiting for two seniors also, so I don't want to take too much time. So I'll just leave it for my senior friends also. Thank you.
Now we have Senior Advocate S. Sri Kumar from Prosecution team.
Honorable judges and my colleagues, now much has been said about 375, exception to 375, and now we are concerned with regard to the exception. Now we are in a civilized society. I am not here to make an anatomy of Section 375 or what is rape, but the necessity of change of law in the circumstances in which we live, the status of women, the change of the socio-economic condition of the citizens, and the archaic law which has been enunciated about 3 centuries ago, I mean, that has been spoken to. And centuries ago, the law has been enunciated by the British. Whether that archaic law has still to continue, especially in the change of the socio-economic status of the citizens of India, not only in the country, in this country, but throughout the whole world, there has been a hue and cry as against the theory of or the doctrine of coverture. Because doctrine of coverture is on the principles that on marriage, the woman becomes the property of the husband, or the wife becomes the property of the husband, both for her all needs, whether legal or social or physical needs. She has to depend upon the husband. That is what Mr. Matthew, not the Matthew the wife who was in the opposition team, but Lord Matthew has spoken as early as in 1736, enunciated the theory of coverture, and that is being followed throughout the country. Even that has been included in our legislature also. I mean, in the law, in the penal law also. So the legislature has then thought it fit, because as now the Matthew that our opposition team has said, the marriage is as a result of trust, as a result of cooperation, as a result of unity. But it cannot be treated as a matter of procreation alone. Because at that time, when the law was enunciated, the status of the women, the presence of the women in the society, their independence is not as of now. Now we have undergone drastic changes. Drastic changes in the sense that there is no distinction between man and woman in the matter of education, in the matter of employment, and in all respects. And they have been treated as equal. If both man and woman are treated as equal, they have got their own independence, not only in the matter of sex, but also in their ideology of sex, in the matter of reference or in the matter of selection of their partner. Because there was a situation in our country in which that the woman has no control or no say in the matter with regard to her spouse. But now it has changed. Now there is a total change in the condition of woman. Even recently the Supreme Court held that women can be in the permanent cadre, or that they have because originally in the defense they were only given temporary status. Now they have been given, because along with the man, the women are also given permanent status in the defense also. That is in the Army, Navy and Air Force. So that in all respects, when the Constitution or the country or the legislature itself accepts on the basis of the intervention of the Apex Court and as well as the High Courts, that they are not inferior to man. So this prompted me to say that the archaic law that the woman, that is the principle of coverture, has still to exist, still to continue in the statute, so as to deprive the woman their right to have their own choice, not only with regard to sex, but with regard to their life. So now we are in an era, or in a modern era, everything is in our fingertip. Now, as said, now there is a total change in the concept of law. Can it be said that the law is static and law cannot be changed? But in view of the various judgments now rendered now by various judges of our High Court, as well as by the Apex Court and various other courts, now there is the judges or the courts wanted to interpret the law so as to suit the needs of the society to the needs of the land as on today. It is not what we are swallowing the law as what has been enacted in while the British was here, or with regard to the amendments that has been bring forth by the legislature, whether that suits the need of the people. Because law is for the purpose of, law is for the people. Law is to bring a social order in the society. If that is the purpose of the law, to bring social order in the society, is not the law has to change according to the circumstances. Whether the law has to be amended, or the court has to test the validity of the law under the under the touchstone of Constitution, or under the legislative competence or violation of the fundamental rights. The law is being interpreted, law is being challenged, and law is being considered in the touchstone of the Constitution. Now, as we know, Article 21 has changed, a drastic change after the decision in Puttaswamy's case. So what is life, or what is the Article 21, right to life? Now it has given a wide concept. So it is not the dignity alone, the dignity to live. That was not the concept in earlier days. But after the advent of Puttaswamy, it has been given a wide range of color. That is, your dignity to life or dignity to your personal life has emerged into a vivid picture in which that everybody as we know has got the right to life. When compared, when taken along with Article 14, when you have got a dignity to life, can it be said that because of the marriage? No, marriage is only a bond in which that it cannot be taken as a procreation. Marriage is only for the purpose of procreation. It is a social status that is being acknowledged by the society, and nothing more, nothing less. And as pointed out by the other side, non-consummation of marriage is also a ground for divorce. So that it is not merely because there was a marriage. It was not necessary that there must be consummation of marriage. There may not be consummation of marriage for various reasons. That is for the spouse to decide. Now, if one has the choice to avoid a consummation of marriage, can the other spouse compel for consummation of marriage? Will it then amount to rape? That is a matter, that is the question that is being raised here, and we wanted to see, our limited interest is only to see that the dignity of woman is protected not only under the under the law of marriage or under the guise of marriage, but marriage does not mean that the archaic principle of the exceptions that has been brought out in 375 has still to continue. So what has been said in 1736 or the law of, or the phenomenon of coverture has to go, because in every aspect, in every field of life, woman is independent. She has got her own voice. She can raise her voice, and she can say that she has got independence, and she can comment upon anything and everything under the earth. And she mostly that the women are holding in the high posts, in elevated posts. And similarly, that I need not say about the position of women as far as in our judiciary is concerned. So in each and every field, woman is respected, and woman is treated as part of the man. That doesn't mean that the woman is a servant, or that she is under the control of man. Certainly, the relationship is so cordial. When the relationship is so cordial, then the purpose of marriage is being continued. But that does not mean that the archaic law, as pointed out my team members, has to continue so as to have the same principle of coverture to continue, and especially when the man is given an upper hand by the law, to criminalize him, but to prevent him from committing a crime. So that is why, to prevention of commission of the crime, we have enacted the penal code. We have enacted the criminal procedure code, and the similar penal laws are there to prevent the commission of offense. So in order to prevent the commission of offense of rape on a wife as against your wish, it is necessary that law has to change. Law has to be changed, because it is the need of the land. And even the United Nations, the Committee on the Elimination of Discrimination, as early as in 91 and 92, has spoken to that, and almost all the countries in America, all the 50 states has eliminated or removed this static law from the statute. Similarly, in South Africa, in Netherlands, and most of the countries, Western countries, they have removed this archaic law from the statute. But still, we are harping upon this, protecting the man, because I don't say that protecting the man, but to protect the women from the sexual assault as from their husband. So I am limiting my words, my time is over. So thank you for. Thank you.
Now we have the senior advocate, Gracious Kyriakos, the last speaker of the day from the opposition team.
Good evening to all. I stand before you as a much relieved man, since my team members have scored so heavily that I need just to play out the remaining overs. When my good friend Mr. Jaju Babu told me, introduce the subject of today's debate, I was wondering whether the debate will take place at all. Because I thought that no lawyer who knows the rudiments of criminal law will come out to speak in favor of the subject. Now, before speaking about the constitutionality of the whole thing, I may just take you through some of the very relevant provisions in the Penal Code as well as in the Evidence Act. The Evidence Act provision, Section 114A, has been mentioned by my learned friend Santosh, so I need not elaborate on that. I need just say something about the explanation 2 to Section 375, wherein consent is defined. That is, consent means an unequivocal voluntary agreement when the woman by words, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. And immediately I will go to Section 90 also. Section 90 of the Penal Code, which says that consent known to be given under fear or misconception is no consent at all. Now, in this background, we will have to go to Section 114A also, incidentally. 114A, as Mr. Santosh has elaborated, says that in a case where consent is in question, then the word of the woman is the last word. So, this is why with these provisions in the enactments, I thought that when one is proposing to the decriminalization of marriage, that is, criminalization of marital rape, it will be a very dangerous proposition. Because when the law is so heavily worded in favor of a woman, what actually will happen if marital rape is criminalized? That will result only in opening a floodgate of litigations. Now we know, and as a matter of fact, when will be a lady coming out with an allegation of marital rape? Only if there is some discord in the marital relationship. And we know very well what now happens. When spouses separate, there will be at least 5 cases. There will be a foreign case, there will be a domestic violence case, again there will be in the family court there will be fight for the children, then there will be divorce case, then from the other side there will be a petition for restitution of conjugal rights and all sorts of. And there will be, if this proposition is held, then another type of litigation will be open. That is, simultaneously there will be a rape charge also. And as you know, rape being a grave offense, there's no limitation also. So I'm really scared, to be honest, hearing some of my good friends speaking in favor of the proposition. If by chance, if this proposition is accepted and marital rape is, that is, cannot be said as marital rape. Marital intercourse is criminalized. All men stands to a very big threat.
Self-fear can't be attributed to others.
Okay. So it will just open a floodgate of litigation only and no tangible purpose will be served. That is one thing. And my friends have stated something in favor of the proposition. And even if it is considered that there is some substance in their contention, still it will be something like using a stun gun or machine gun to kill a mosquito. Or else just borrowing a saying from our own mother tongue, എലിയെ കൊല്ലാൻ വേണ്ടി ഇല്ലം ചുടുന്ന പോലത്തെ ഒരു പണിയായിരിക്കും ഈ പ്രൊപ്പോസിഷൻ അക്സെപ്റ്റ് ചെയ്യാന്നുള്ളത്. ഓക്കെ, നൗ ഐ വിൽ കം ടു ദി കോൺസ്റ്റിറ്റ്യൂഷണൽ ആസ്പെക്ട് ഓഫ് ഇറ്റ്. What actually is there in section 375? As you know, as per 375, a woman cannot rape a man. So, one party to the marriage is already protected. Now, as per the explanation, it totally clarified that none of the parties to the marriage can be punished for forced sex or sex without consent. So, criminalizing the marital intercourse as rape will be doing violence to section 14, article 14 of the Constitution. Because one party alone is being discriminated. Now, just to avoid that discrimination, it has been made clear in the section that a man will not be held liable if he is having physical relationship with his wife. Of course, if she is above 15. So, only to bring parity, such a provision has been introduced in the provision. And now, incidentally, I may take all of you to one more provision, that is section 376B of IPC, wherein 376B, wherein there is a provision that a person having sex with a separated lady without her consent, that is made an offense. And you may just see the punishment. It is punishable with imprisonment up to 7 years. And 2 years is the minimum punishment. Whereas for rape, if the proposition is carried on, then a man who is living with the wife will be liable to punishment for a higher offense. That is minimum imprisonment of 7 years, which may go up to life imprisonment. Whereas a man who is doing a graver offense, that is having sex with a separated wife without her consent, will be let off with a lesser punishment. This aspect also will have to be borne in mind while my friends, if they are still insisting that the resolution must be carried on. Now coming to the constitutionality. As I have already stated, there is no violation of Article 14 at all. So, only to bring parity to the parties to the marriage. At this point of time, we need not just describe them as man and woman. We can just describe them as party to the marriage. And of course, always a party to a marriage can walk out of that relationship even without either a judicial separation or divorce. See, a party can just decide to live separately, so that the question of having being subjected to violence or sex without consent will not arise at all. So there is a purpose for the institution of marriage. If this proposition is carried, then the very institution of marriage will collapse, and that will play havoc in the society. So with these words, I conclude. Thank you.
Thank you, Gracious, and other speakers. We have a lively debate, and I think I had to ask the first question after hearing both sides. The men here and are so vigorously defending the rape, obviously for some reasons. And men on the rights also propose that this law is archaic and it has to be struck down. But after hearing Mita, something has come to my mind. See, if you look at the scheme and text of penal laws, you can find the focus is on the individuals. And if you look at the very idea of penal justice, we find that deterrence is one of the ideals. So that would ensure a certain kind of protection of a person who may likely to suffer. And if you look at the rape laws, you find there are two dimensions. One is related to bodily harm and bodily injury. The other is related to consent. The consent, of course, normally a party become consent, then it may say that vitiated for different reasons. But what about bodily harm is caused? A bodily injury is caused. That's other part of the rape law. Now, a woman can be distinguished when it is bodily harm is caused based on a marriage or not? So she argued that they are unequal, and that's where my problem. How do you treat them as unequal merely because of marriage as different for the different purpose? All the scheme of the marriage institution as the marriage is different. And you must always remember the laws are made because we have a mutual fear. This is how the law came into existence. And we want to see that each other is protected. So how do you distinguish when women in a marriage and not in a marriage, insofar as it relates to bodily injury and hurt?
Now, Mida has given me a senior engagement. Now, there are enough provisions in IPC to take care of such situation. Whenever bodily injuries are caused to a woman or a party to the marriage, right from starting from the section 320 onwards, there is, depending upon the nature of the bodily injury, the hurt caused, IPC. Now the proposition is only that is regarding having marital physical contact without the consent. But if a physical injury is caused, that is an entirely different aspect of the matter. IPC provisions are there. If a simple hurt is caused, either 323 or 324 will come into play. If grievous hurt is caused, 325 or 326 of IPC will come into play. If death is caused, of course, or culpable homicide is caused, section 300 onwards, section 299 onwards.
No, I'm not on that point. Of course, I don't want to discuss. See, the act is same as far as the women in marriage and not in marriage. That bodily injury is the same, the forcible act. That's why I am asking you how the exception could relate to that harm and take the perpetrator of the crime out of the rape law. The bodily harm is same as far as the women in marriage and not in marriage. Injury is not the forcible act. The law contemplates the rape in two ways. One is a forcible act. Other is based on a consent. Still, it qualifies a rape, but for certain reason, for vitiating element. But as far as the forcible act is concerned, it's the same as far as the wife or without party. Statement by the wife that there was no consent No, that is different. That's a 114A's presumption is totally different. Even today, it stares at men. Women come and speak in terms of 114A, and the law presumes an act. That's a different. It's a process of proof. But as far as the law is concerned, law is very concrete. It says that a certain forcible act would constitute a rape. It enumerates. But for you are in a marriage, the law protects.
Now, may I just add something more?
Bodily injury, I'm not saying the bodily injury means like a grievous hurt or other hurt. In many of a rape, there may not be any scar even, but it is a forcible action as against it. It's a bodily injury. Law penalize it because of injury. In a sense, it can be a mental injury or any way.
No.
Yes.
Force is not an issue at all, because what is sought to be criminalized is sex that is going by the definition of rape. It is sex against, without her consent or against her will. Sometimes, just like in law enforcement, some force will be necessary. We will have to discount it.
Yes.
I just stopped by that.
I think youngsters here can ask first question. Yes, youngsters, we prefer the youngsters. You can come, We just give up. There are 6. You can ask 6 questions. We have to wind up. So any youngsters who want to ask question? Thereafter, we can give an opportunity.
I'm Hannah, and I find it deplorable that the lawyers have put forth that the sanctity of marriage would fall through.
But you can ask the question. You can deplore later.
Yeah, and it's deplorable that the sanctity of marriage is at question if marital rape is criminalized. And my question is about the judiciary. Can the judiciary really wash its hands off in the situation and say that it is incumbent only upon the legislature to frame these laws, and wherein the judiciary has in many instances acted on its own accord? Judicial activism has been the harbinger of change in many situations. So why not in this instance the judiciary take up an active role? Why is it that we have to wait for criminalization of these offenses? And again, very deplorable that those statements were made about the sanctity of marriage.
You have not asked any question, and of course, we can leave this question later.
Sir, my question is about criminalization, if it should go to the legislature alone.
Yes.
Anybody can.
Question is directed against.
Anybody can answer, anybody on the dais.
I'll just try to answer that question. We have been given a topic we were supposed to speak on. So please don't be judgmental about the content of what we have spoken, because we were given this particular version and we had to do that job. So that is the role of a lawyer, which we have done. And please don't think that it is our personal opinion also. But having said that, we covered that there cannot be a judicial activism to criminalize an offense. And we have based it on sound legal principles also. It is the prerogative of the legislature. They need to have detailed deliberation regarding the implications and the consequences. There should be different yardsticks also. Now, having an exception alone, when there is an evidentiary principle like Section 114A staring at your face, you may not be able to withstand a complaint which is filed, etc. So, there are restrictions or limitations on the judiciary also to criminalize an offense. So please keep that also in mind, that even though judges become judges, but they can only interpret the law. Yes. They cannot, I don't think they can declare the law or say that this should be a criminal offense, etc.
I think in general context is right. But I can't subscribe to you in this particular context. In the sense, the law has to be tested on the envelope of the Constitution. It's not the judiciary makes a new law, penal law. The question is whether there is a different class, the same class is being treated differently. That can be tested by the court. That is possible in this particular context also. Generally, he's right. Judiciary cannot make a particular act as an offense because it's left to the parliament. Absolutely, I agree with him. But in a particular context, whether same class of people can be treated differently, that can be looked into by the judiciary. I think there is a scope for judicial intervention to extend particular law is unconstitutional or not. That extent judiciary can, yes. That's a different, as far as this concern is concerned. I think as you can't make the very fundamental of rule of law propounded by Dicey. If you look at the three classifications made, there should be a law prior to existence in regard to punish a person or penalize a person. That is the first proposition of the Dicey. Yes, you can ask the question.
Do you want an exception which is perpetuating doctrine of coverture? Because as per doctrine of coverture, once the woman enters into the institution of marriage, she relinquishes her legal rights. So she is not an independent legal entity. She is getting consolidated into the husband. That is what doctrine of jurist Hale said. So the scenario here is both wife and husband is one and the same, where wife is not enjoying any legal rights to initiate or institute any proceeding against the...
What is the question you want to ask?
Question is, do you want to have something which is going to perpetuate a paternalistic notion? Okay, this is...
You are asking question to him or...
No, I am asking this question to those who are opposing this.
Okay.
And let me complete it, sir. One more thing, sir.
Yes.
Just one more thing, sir. Because this particular exception I am trying to say is, it is violative of Joseph Stein versus Union of India judgment. Because you please go through it, a circumstantial reading of the judgment tried to say that the Constitution of India does not countenance any degree of paternalistic notions. We want an egalitarian society.
Yes.
I'm sorry, which judgment did you refer to?
I am referring about Joseph Stein versus Union of India judgment.
Adultery. Yes, yes. So the distinction that I can draw there with that matter is that, as Santosha rightly pointed out, in that case, 497 was decriminalized. That is something which can easily be done by the courts. But when it comes to criminalizing a matter, the issue is that you are taking away the rights of a certain class of people. Whatever classification you're suggesting, you're taking away those rights. And once those rights have been taken away, the offense will continue to persist against them as well. So whether that can be done by the judiciary is one question which we raised. And another thing is, see, as I had mentioned, even the offense of rape developed from these laws of coverture. In erstwhile times, women were considered as property of their husbands or their fathers. That is why rape law actually came into force, because a woman's virginity or her chastity was considered to be a very valuable asset. But we have emerged, or we have evolved to view these laws from a completely different perspective, grounded on the issue of consent. Rape laws have evolved to pivot themselves in the concept of consent and the fact that individual dignity cannot be violated. What I'm trying to say is that this same perspective ought to be adopted while we're viewing this exception. See, a practical difficulty with regard to marital rape would be, would you impose the same conditions that you do for a normal or for a usual rape case? Would the victim be expected to live with the person who she considers to be her rapist when the trial is going on? Or would there be no bail granted? There are a lot of issues that will come. The basic issue is that we are in a sociological scenario where women, even when they enter into marriage, whether their consent is real consent or not.
Answer. Any other questions? Any supplemental question on this? Yes, Aditya.
Am I audible? Yeah. This is a very serious issue to be looked into because there are a lot of young men.
Yes, recently married may face serious
a lot of young men who have just married, and there are a lot of people who are looking forward to get married also.
Yes.
So the problem here is that once this is criminalized, how do you check on the number of issues or cases that is registered against the woman or registered by the woman? How do you check on all these cases that is given against the men? How is it possible to check, or how is it possible to prove also? It will be very difficult. Any offense that is alleged will very easily be found against a person? How can you prove that?
I think I 1 minute. Question like this, in fact, is something which cannot be, put in the jacket of and kind of norms to be applied in constitutional terms. So practical, like Gracious has pointed out, it may lead to a dangerous proposition. Even today, 114A stares at every man. So that cannot be reason to test a law based on Article 14. Practical difficulty even assumes, there exists today even. So the... I need to quote on the yes.
That is 370. Section 375 is there. That is a general provision. The exception that has been carved out, that is some explanation 2 or exception 2, whether that is valid or not. Here we are not seeking for criminalization. Now an exception has been granted to married man, whether that is valid or not. If that goes, the original enactment or this section 375 as it stands is there. It only gives an exception. Whether the exception is valid, there is no criminalization. The law as it stood will stand. No question of criminalization. There is no question of any anxiety in the case of marriage. But whether exception can be granted to a married man. No, it's only true since the exception has been granted to a man from indulging in rape to his wife. Whether that will be a deterrence, whether there shall be a deterrence or not on that. So that there won't be much act on the part of the husband and the wife for the purpose of rape. So in order to protect the wife, the exemption or the protection that has been granted to the husband has to be taken away. That's all.
If there is an hurt or grievous or assault, a wife or husband can be booked. But exception is only on certain things. Yes, any other questions? And I think, except lady lawyer young sitting behind, no one from this side has asked any questions. So we'll wind up.
I humbly request the moderator to give the concluding remarks.
Thank you for providing such a platform for the lawyers to come up and vent here. Of course, tomorrow, if Santosh is paid, he will argue on that side. So please don't carry away the impression that he was defending or proponing. Same thing has happened also on the other side. And this should happen in our, especially to, as I said in earlier opening remarks, we need to guide youngsters. They're all now on the fingertips of searching the law journal, or the citation on Google, on India card one especially. So they don't look into the reality beyond. So they need to know the reality, the context in which different proposition of law is generated. And this is the way their ideas, their thoughts can be expressed. I think every month the debate committee will hold such a debate, and that should happen every month. And especially Jaiju Babu is there, and he will sponsor many things. So I hope this will be a continuing affair. Thank you.
Thank you, sir. Now I invite Dr. Tushara James, Secretary, Constitution Debate Club, to propose the vote of thanks.
Good evening, everybody. United States Supreme Court Judge Justice Joseph Story's time-tested statement that law is a jealous mistress could not have been proven more right than today. That is why senior judges and lawyers of this court are spending time here at this time of the day, sandwiched between 2 working days, loving difficult debates on law, blissfully ignoring probably easier commitments at home and office. My role is to formally thank the moderator, the participants, and the judges and lawyers present here today. I thank on behalf of the Constitution Debate Club the moderator for the day, Honorable Mr. Justice Mohammed Mushtaq. Probably it is his handling of the matrimonial jurisdiction in a very unique and gender-neutral way, along with Honorable Justice Sophie Thomas, that has triggered the introduction of this very, very lively topic. Thank you, sir. I thank the speakers, Senior Advocate S. Sri Kumar, Advocate Karthika Sukumaran, Advocate P.G. Jayashankar, Senior Advocate Gracious Kuriakos, Advocate Santosh Matthew, and Advocate Mita Sudhindran for consenting to be the participants for today and enlightening this crowd with their unique contributions on the subject that has been under discussion. I thank on behalf of the Constitutional Debate Club and on behalf of myself the honorable judges who have been present here today. I'm sure Honorable Justice Bechu Kurian Thomas would have more to think of, probably reminiscing of what he was as a participant in one of the earlier sessions as well. You are very actively involved in the whole process, and it has been always a delight for the club and a privilege as well to have the judges giving their valuable opinions while we were actually planning for this program. I thank the Kerala High Court Advocates Association under the able leadership of its president Rajesh Vijayan. Hopefully we'll have more Facebook posts from him as well. The secretary and the committee members for extending all support for the program. I thank the patron, Senior Advocate Jeju Babu sir, and the mentor, Senior Advocate P.K. Ravindranath Menon sir. Unfortunately, he's not present here today. But both of them who have been the guiding light for the debate club for all its activities. I thank the lawyers present here today, actively supporting and participating with their questions, pointed and sometimes blunt too, giving both enlightenment and entertainment. Thank you very much. I also thank the committee members under the stewardship of our President Advocate Parvati Sanjay, all the members who have been actively involved in organizing the program and also its arrangements. The Advocates Association and the team who have arranged the light and sound and other arrangements as well are also thanked deeply. Thank you very much for being participants here in this program, and considering the manner in which the debate has taken place, in all earnestness, I wish you all a very good and peaceful night. Thank you.